Tom Abbate with Parnham and Associates. Today I'm going to talk to you about homicide charges in Texas. And really there's four main vehicles that you need to worry about. Those are capital murder, regular murder, manslaughter, and criminally negligent homicide. And I'm going to go through and lay out each offense very briefly, talk a little bit about defenses and punishment ranges, and what's important to keep in mind whenever you're picking an attorney if you are charged with these things. Now, to start off with, the highest murder charge, and really the highest charge that we have, is capital murder. This always carries a sentence of either life or death if you are over the age of 17 when you are alleged to have committed the offense. What the state can do is, in bringing the charge, they can seek the death penalty, where they'll have to prove future dangerousness to show that you're really not deserving of filling out the rest of your life, or they can just simply opt to not have a punishment phase and just send you in for life without parole. Often increasingly this is the way the state is choosing to proceed, because they only have to prepare for half a case, which makes it a lot easier on them. Now, in order to be charged with this, the state has to allege that you either killed 2 or more people all in one criminal transaction, that you shot and killed a off-duty or on-duty law enforcement officer who's in their uniform, or that you were committing an inherently dangerous felony, like, say, burglary. Things went wrong and someone died as a result. Those ones are very difficult to deal with, just simply because you've either got to deal with a future dangerousness issue and arguing that your client, although his actions here may have been, less than acceptable, do not necessarily reflect how the rest of his life is going to go. Other than that, if they don't choose the death penalty, well, you're pretty much stuck with life without parole, and you have no opportunity to argue for anything less than that to a jury, so long as they become convicted of capital murder. Now, the second murder charge that we have is going to be felony murder or first-degree murder. Often this is an intentional killing or someone committing a felony not listed under capital murder, and death results. A good example is, say someone has drugs in the car, cop goes to pull them over, they decide to gun it to try and get away, and they run over a pedestrian. Well, they didn't really mean to kill that pedestrian, but they were already committing a felony in evading, and someone's death resulted. That carries a punishment range of 5 to 99 or life. This one is a little bit easier to deal with because, you get that punishment phase, and that punishment phase is where you get a chance to really humanize your client and show that, even though the jury believed that they committed this offense, that they're not completely without the ability to be redeemed. They have some good qualities. As an attorney on those kind of cases, I like to spend a lot of time on preparing for the punishment phase. I'm hoping to beat it at trial, but if I don't, I want to make sure that the jury understands that this is a human being and this is someone that has worth, okay? Now, under that, you have manslaughter. This is where you're not necessarily intentional in your actions, but you're reckless, okay? A good example, although not truly under regular manslaughter, is intoxication manslaughter, which is kind of a side charge to this. This is where, say you've been drinking at a bar, you're driving home, you're too intoxicated, you hit someone, they die. You didn't mean to kill them, so it's not intentional, but you were definitely being reckless by driving while intoxicated. At least that's the way the law sees it, and so they're going to punish you for that homicide. This one carries a punishment range of 2 to 20. It's a much lower felony. The law does understand that you didn't intend for this to happen, but it did happen, and it's because the law feels you were being reckless. Under that, and the final charge, we have criminally negligent homicide. This is going to be where you weren't intentional, you weren't necessarily reckless, but you were grossly negligent, okay? And the easiest example that I can give is, if you're familiar with Houston, every January 1st and July 4th, when people are firing off fireworks, some people feel the need to fire off a handgun rather than going and buying those fireworks. Those bullets eventually come back down. If they were to hit someone and kill them, then you would potentially be facing a charge of criminally negligent homicide, in that you didn't mean for them to kill them, you weren't necessarily being too reckless, but you were definitely negligent in terms of your actions. This one, though, only covers 6 months to 2 years, so it's a much easier charge to deal with. But some of the defenses that you would normally have to it are not going to be there. And let's get to those, which the main defenses to these is always going to be, first of all, identity. The defendant is not the one who did this. A lot of times with, say, a murder charge or a capital murder charge, a big investigation was done. The law enforcement will come up with maybe 2 to 4 suspects, depending on how their investigation breaks out, and they inevitably choose one over all of the others. As a defense attorney, in defending that kind of a case, I want to investigate I want to look at what the investigators did, look at their suspect, and then I want to start going out and looking to see, is there anything they missed that makes this other suspect a more viable candidate as the defendant, and then put that in front of the jury to show that, yes, there was a death, it's very tragic, but the state has the wrong guy. And so it's very important that you investigate that on the front end. Second defense, which will be covered more thoroughly in another video, is going to be self-defense. You're arguing that the other person was the initial aggressor, they came at you, you needed to defend yourself, and it's unfortunate they died, but it was either them or you. That's a very important defense. It needs to be explored very thoroughly in any time that you're looking at getting ready for trial. The third defense is not so much a affirmative defense that will necessarily get you off of being guilty, but it can adjust the charge downward. So for instance, murder requires intent. Capital murder requires that you intentionally did these things, or that you were doing something very dangerous and these things happened. One way to argue is that maybe you didn't intend for this to happen. For instance, maybe you're in an argument with someone, things get heated, they pull a gun out, you go to grab it just to keep everything kind of calm and safer, and the gun goes off, they get hit, they die. Well, you didn't intend to kill them. It's not necessarily self-defense in that you did not take an affirmative action to defend yourself that intentionally resulted in their death, but maybe it drops it down to recklessness or negligent. Maybe you were both drinking when you were having this argument, and while they were being unreasonable, you maybe weren't being all that reasonable yourself. It's going to be very fact-specific. That also brings me to sudden passion murder, which is kind of a drop down, like taking it from murder to manslaughter, but the difference is you get found guilty of murder, and then you put it in front of the jury, an argument that, look, I did these things, but I didn't intend to do them. I was overcome by emotion, some sort of passion that overrode my logic, and the death ended up resulting. This will take a first-degree murder down to a second-degree penalty, so it'll be 2 to 20, but you have to argue that in some way your logic and mental faculties was overridden by some kind of occurrence that caused a great deal of emotion on your part, and that the jury believes that this is reasonable. This exception or caveat was originally produced to cover when one spouse comes home and finds their spouse in bed with another person. They draw a gun, they shoot them both, they argue to the jury, well, I was just so overcome by her betrayal or his betrayal, whichever it may be, that I lost my ability to think reasonably. It's going to be very fact specific, and I don't know how well it would necessarily work in the way that it used to, but it is still available as a defense if you can get there. A lot of times this comes up in a marriage situation where the two people, maybe the marriage has become very toxic, they're arguing, and things just get out of hand. So it's very important that when you're choosing an attorney, you choose someone who is willing to investigate everything to the fullest. The alternative perpetrators, or that you just simply didn't do it, you can always let that stand based on the state's case, but the better defense is going to be someone who actually goes out and investigates that other suspect and finds additional things maybe that the law enforcement missed to tie them to this and brings that into court. It's also very important that you tell your attorney everything you know, because we can't necessarily work on a shortage of information. We need as much as we possibly can, especially if you're going to try and claim something like self-defense. That defense needs to be thoroughly investigated, and your own personal history needs to be thoroughly investigated, because with everything other than capital murder, you will, if you are found guilty, you will get a punishment phase, and it's very important that your attorney humanize you to the best of his ability and to show all of your good qualities to get that punishment down from life or 99 years to something that's a little bit more reasonable.